Thank you very much. So my name is Mona Caroline Chammas. I'm the founder of Govern and Law, and I'm absolutely delighted and honored to introduce Verica. I trained to pronounce your last name, but I won't dare in front of this beautiful audience. Why it's very special actually to have this talk in a nutshell. In human rights, I don't know how many of you after law school thought of practicing human rights, but most often it meant to go to non-profit. And in the business, there was not much talk about human rights. And today, with the fourth industrial revolution, we are actually seeing that we are bringing the sexy back of human rights inside the business. And I think here we have a bit of the two sides. If you think of the sea, I practice underwater with companies, and we have here the amazing experience of a judge, an advocate general, a professor, who has seen the tip of the iceberg, meaning when there is litigation about human rights, when there are problems. Below the tip, and I think that's where we all have a role to play, and actually that's why I also founded my firm, is that we talk a lot about ethics. But what's the efficiency of ethics? What's the democratic legitimacy of ethics? Today in Europe, we have more than 100 guidelines about ethics. Companies draft their own ethics charter. But can we just read them and realize that most of these ethics guidelines are just translating fundamental rights and freedoms? And the beauty about fundamental rights and freedoms, to the extent we know, is that it's at the level of constitutional law or even higher, with binding effects, with accountability, and even with courts in case things go wrong. So as we talk about transparency, about accountability, and about fundamental rights, even companies within their strategy making should be caring about, I think the momentum is now for lawyers, engineers, strategy makers, CEOs to come together to have more of a real debate about human rights and how we want to give them a new life, a new era in the digital arena. So that's an introduction also of how relevant it is to have you, given your experience. The CV is short, but just reading it, it could make actually 10 pages because it's extremely impressive. So in a nutshell, Verica is now a member of the Permanent Court of Arbitration in The Hague, professor of EU law in Austria and Slovenia, and she's also, very interestingly, member of the executive board of the EU Agency for Fundamental Rights, which is in Vienna, I guess, right? She was judge of the General Court and advocate general. We all know how prestigious that function is at the European Court of Justice. And she told me that indeed Katerina was her stagiaire and a very good one. So that's for you, Katerina. She wrote more than 300 articles. So I would advise that you look Verica up to see the beauty of her writing. I asked her what were her three drivers as a woman and in life, and I think it connects very nicely to what we said this morning. Honesty, diligence, and endurance. And she said the last one is probably the most important for women. It was true years ago, it's still true today. And last but not least, I asked Verica, if you were going on an island, which human right would you pick? If you had just to go on an island with one human right. And she's in fact very pragmatic. She said the right to life. So Verica, you have the floor. Thank you so much for being with us today.
Muchas gracias. Buenos días. So, dear colleagues, dear ladies and gentlemen, it's really great pleasure to be with you today here in Madrid. And thank you also for this nice introduction. Yes, as I have explained already, Katerina Miller, thank you very much for this invitation. She was also, when I worked at the court, my stagiaire, and really one excellent one. So that congratulations also to your excellent career. Today, I'm going to speak about, actually my speak is not gender-oriented, so that I'm going to speak about our human rights in digital age. What are the new issues in this area? How is this going on? Okay. You know, it's always a problem for me when I have to ask a man to help me. But this is only technical help as I wanted to ask before. No, it's okay, it's working. And I have a son, 16 years old, and always when I have a problem with my computer, I always work, and Marco, it's the name of my son, Marco, I have a problem, and then he always say, but you are so, so important lawyer, and you don't know how to solve this problem. And I said, but this is only a technical problem, and I am here for the biggest problem, so that this is also a point of view how we can decide, or define our role. Our role is very important so in our life, even if we need sometimes a man's help. So now I would like to start with the question for you. What is your most important human right? Life, okay, it was mentioned because this was an option for me when it's only one life.
Choice, the right to choice.
Okay, yeah.
Gender equality.
Okay, yeah. Dignity, freedom, yeah. Sometimes I ask also this question, also I ask my students, and there is not always the same question, or they even don't know what to answer. Then I ask maybe actually education, or maybe consumer protection, or like normally we answer in the digital age, I think we are going to answer privacy and data protection. But I know that we all like our right, how is this? Right to paid annual leave, vacation, Do you know that this is also our right according to the EU Charter for Fundamental Rights, Article 31. We have the human right, if you work, to get a paid annual leave. So that this is really important to decide. And the question is if we have in the digital age a special rights, or they are actually the general rights in all areas, like data protection, privacy, information, property rights, especially important in the digital age, intellectual property. Freedom to conduct business, important for enterprises, startups today, we have this discussion. Or do we have really a new, as my son answered me, when I said that when I explained to him that I'm going to speak about human rights in digital age, and he said to me, yeah, we have human right to internet. But I'm not completely sure that it is really a new human rights, because it can be divided to other human rights. Or do we have, I'm going to speak about this at the end, right to a judge as a human being, not as a robot. This is also one new question and new problem, so that I'm going to speak in three areas. First is what comes first, practice, law, or court. Then I'm going to mention one case from the European Court of Justice, Google Spain, it's a Spanish case, and then about our future human rights in digital era and lawyers, what is important for us and what is going to be then in the future. So what comes first? Is this a practice? Is law or the court? Where is the problem? In the practice, sometimes there is a problem, and we still don't have a specific law for this. Like, for example, self-driving cars or Uber. Yesterday, I think it's very important here in Spain. We don't have a specific law, but if there is a problem in the practice, somebody has to answer, and there is then the court. So that when it's a practice, I think it's better that the first step is always practice, because if the law is going to be as first, then this could be, the problem for the development. So that the law can regulate the new field, but at first should be the practice, and then if there is a problem, the court has to answer, even if no specific, I would like to stress, if no specific legal basis are enacted. Important is also to stress at the beginning human rights and digital technology, so that how human rights impact technology, and on another side, how does technology impact our human rights, so that we have to be aware about this interaction. Now, to stress our legal framework in this area, in the EU we have a new EU Charter on Fundamental Rights. It is in force since 2009, and the competent body for this interpretation is European Court of Justice in Luxembourg. just not to make mistakes, we have also in Europe, in the broader sense, European Convention on Human Rights, and the competent body for this is European Court of Human Rights in Strasbourg. Yesterday we have heard this is the body of Council of Europe, not of the European Union. Also 47 member states, for example, Russia is also a member of this. But as you know, the European Convention on Human Rights, at the end then is the problem, could be the problem with enforcement, which is because it's not the same as in the EU, when we have also the enforcement system. So that when we speak about human rights and fundamental rights, for these lessons it's actually the same, because the content is more or less the same. So now about as I said already, about the legal framework. In the EU we have European Charter, we have EU Charter, European Charter of Fundamental Rights. I have here two books, this one and this one. Which one is the EU Charter of Fundamental Rights? The small one. The small one, you know, it is not important how big you are, but the content is important, so that this is, as I said, as I always say to my students, it's a small book with big rights. This is actually, we have to be aware, this is our constitution, European constitution, in the area of fundamental rights. We have really to be aware of this and to be proud that we have such a legal act in the European Union. I have few booklets with me if somebody would like to have this in English language. I have this here. So that this is EU Charter. It's a primary law. It's obligatory in the European Union. And in the EU Charter, you can find some rights very important also for the digital age. For example, right to privacy, very important. Protection of personal data. Right to property, especially intellectual property. Freedom to conduct business, important for companies. Right to an effective remedy and an impartial trial, this is actually judicial rights. And prohibition of discrimination, also not to forget, because it's also, for example, for women important, it is forbidden, discrimination on the basis of sex is also forbidden. And other rights like dignity and so on. If there is, as it is in the normal life, a conflict between two human rights, then we need a body to decide about this. And at the national level, it's a national court. At the EU level, it's the European court. For example, there is always, very often, in the majority of cases, is a conflict. For example, if you are an internet user, you have a right to privacy. This is my right to privacy, and right data protection. But if you have a startup, you are an enterprise, you are Google, you are Facebook, right to conduct business is my right. And right to information, but right to information in this sense that I can deliver the information. You know, so that there is a conflict, and at the end is the court has to decide. So that, and now I'm with this part about the role of the court in this area. I'm going to stress the influence of the European Court of Justice, with the seat in Luxembourg. I have mentioned already, even if we don't have a specific law, there is the court has to decide. This was the case Uber, Airbnb, Bitcoins. We have already judgment of the European Court of Justice. The court has decided already, but it should be valid in all member states. But this is not actually connected with the human rights. But then we have another right to be forgotten, another problem, right to be forgotten. What is in this case? Do we have this right to be forgotten if something is published online? So that this is only the photo of the European Court of Justice, this slide, and just to stress that this is actually the mixture of Constitutional Court and the Supreme Court. This is, anyway, it's the highest court in the EU. And why the judgments are so important, just maybe for non-lawyers, because the judgment of the European Court of Justice are obligatory in all member states, at the moment 28, then after Brexit, if it's going to be, I'm not sure, then 27 member states, and they are obligatory for more than 500 million of Union citizens. Now I'm going, as I said before, I'm going to explain one case, which is very important for digital age. This is case Google Spain. It's a Spanish case, and the main question was, do we have the right to be forgotten? as a student, you have published a lot of photos about your parties and so on, and then later, when you would like to make your career, you would like to delete these photos, but the Google will not answer on your request. Do you have this right to be forgotten? This was, as I said already, the Spanish case, concerns the protection of individuals with regard of processing of personal data. Then what is the responsibility of Google in such cases, or not only Google, all similar enterprises? Do we have this right to be forgotten? And this was the procedure was preliminary ruling from Spain. This means that the Spanish National Court asked the European Court how to interpret the European law. But what were the facts in this case? Just to mention, there was one article published in your newspaper, La Vanguardia. There was one article about somebody who had financial problems, and this article was still available on Google. Also 10, or I think it was in reality 12 years later, it was still available on Google, and this Spanish national wanted or asked Google to delete all links concerning this information. And then what was what was important as a legal basis? At first, this was this old Data Protection Directive. This is an old one. And then Charter of Fundamental Rights. As you can see, 4 rights when the Court of Justice had to decide which right has actually the priority. And there was respect for Article 7 and 8. This is privacy. Article 7, or respect for private life. Article 8, protection of personal data, data protection, and then these 2 rights more important for internet user. No? And then other 2 rights, freedom of information and freedom to conduct business, as I have mentioned before. In this case, was very important, but it's more actually interesting for lawyers that Advocate General decided in the, how to say, in favorem, in favor of Article 11 and 16, but the Court of Justice decided that the privacy and personal data have a priority in our life, and that this is now the obligatory decision for all member states, and then right to information and right to conduct business actually are in this case, in all such and similar cases, not so important. So that the court decided that the Google is responsible for the processing of data, even if this information was published by the third party, as in this case by the newspaper La Vanguardia. And then, this is maybe too much text, but just to say, we have the right, if somebody would like to have PowerPoint presentation, I can send you, it's sometimes more text, that we as an internet user, we have the right. Data subject may approach the operator directly. This means that we can demand Google to delete our data. If Google is not going to respond, then we can ask the competent authorities in our member states. This is the court. And this is now how the court decided about this balance, fair balance between different fundamental rights. As you can see, Article 7 and 8, this is privacy and data protection. Those rights override are more strong than 2 other rights, then economic interest of the operator and also the right to information, also the interest of the general public in having access to this information. There is only exception is, as you can see, however, that would not be the case if somebody is a person in the public, where in this case is the public interest for this information bigger. For example, if there is a politician or a minister, for example. So that the winner in this case, I would say, is in this way, it's freedom of privacy and protection of personal data. And what's very important, the reaction of Google in this case. Google really was very proactive and published such right to be forgotten form, so that then how important this personal data data protection or privacy for us is, you can see here already a few days after this, more than 40,000 people already demanded to delete the information. And now, today, the problem was, in a way, I would say, solved, because after the judgment Google Spain, we have got then General Data Protection Regulation, and this Google Spain judgment is today already in the new, in the Article 17 of the Data Protection Regulation. This is also the name of this article, is right to be forgotten. So that this was the development, and this actually shows the importance of the courts at the national level, and for me, I wanted to stress the importance of the European Court. And now only a few minutes about the future. What is then our role as lawyers in the digital age? You see, this is one photo. This was my first conversation with a robot 2 years ago in Luxembourg in one conference about the consumer protection. And really, actually, I was not aware that the robot is always a man. So that also when I wanted to find a photo then for this PowerPoint presentation, it was very difficult. I found only one photo that there is a woman as a robot. So that I'm not sure if this is a discrimination, but I think this fact is something to think about this. It's this good or not, it's difficult to explain in this very short time. So that today, do we need a new digital human rights? My answer would be no, because we have already all these rights, data protection, dignity, rights to privacy and so on, so that we only have, not we, but the court has to explain this in a broader sense, in a modern sense for the digital age. And as said already, human rights, do we have this right to internet? I think this could be connected with the right to education or a right to get information, so that it's not necessary to have a new right. According to this right as a human right to a judge as a human being, I'm going to stress in the next slide. And what is important for us as lawyers to see digital technology as something what is our friend and our assistant, what help us. It's not something what causes a problem, because we all need information technology to be successful. So that do we need a judge, do we have a right to a judge as a human being? This is going to be a problem in the future, because as you know, especially in China, they have already the courts when the special, not robot, but algorithm is actually a judge. What could be the problem in these cases is, in all such cases, is for me personally, that the judge has to be not only a very good lawyer, but also what is his personality. This is to be honest, to respect dignity, and this, this personal, all these issues, so that this is the problem with AC, so that, for example, this second question, will this still be a fair trial as required by the, for example, EU Charter? And how will the algorithm know how to decide fairly? So that this is very important, so that I think we will always need a judge as a human being, but we don't need for this as a new human right, but this could be the part of this Article 47 of the Charter, judicial rights, that we have this right to fair trial. So that this is something what is going to be important for the judgments in the future. So the conclusion, just to stress again, in digital era, important is also, all this is important, we have new practices, new legal problems, new legislation, but solution, it's necessary to have then the case law if there is no solution in the legal act. And we don't need new human rights for digital age, because we have already human rights in the EU Charter. And actually here you can see as a woman, as a robot, but it was so small that it was possible to find a bigger one. I would like to stress with 2 slides concerning the quotes of important persons. This one is concerning human rights in general. This means concerns also our human rights, because human rights are also women human rights. Human rights are not a privilege conferred by government. They are every human being's entitlement by virtue of his humanity. Very important to know this. And what is about the technology? We are not the first who are asking this about the digital age. As you can see already, Albert Einstein was aware of this problem, and already he said that the human spirit must prevail our technology, and I hope this is going to be in the future. Gracias. So. A foto.